TikTok. Time has run out on one of the most popular social media platforms in America. But what if I told you that one of the most controversial topics in today's society is one of the least controversial inside the halls of government in Washington, D.C., and one of the most bipartisan issues in Congress? And now, with a unanimous Supreme Court ruling in TikTok v. Garland, what is the future of this social media platform? And what about the millions of users that use it across the United States? We're going to dive into those questions and more with Dr. Adam Carrington of Ashland University. That's all coming up right here, right now. I'm Sam Chen, and this is Face the Issues. Good evening and welcome to Face the Issues. I'm Sam Chen. It is one of the most popular social media platforms in the United States with millions of users from coast to coast and millions more around the world. And the decision to ban TikTok in the United States has been one of the most controversial outside of Washington, D.C. Yet in a society where voters have clamored for more bipartisanship, the ban of TikTok has been one of the most bipartisan bills that Congress has passed in recent history. And with the current Supreme Court ruling in a 9-0 unanimous decision that to uphold the law that Congress passed, the question is how do we get here? Where do we go from here? And what all happened to get us to where we are today? We're joined by Dr. Adam Carrington, longtime friend of the program, a constitutional scholar, currently serves as associate professor, Archer endowed position in history and political science, and the co-director of the Ashbrook Center at Ashland University in Ohio. Adam, welcome to Face the Issues.
Glad to be back. Thanks for having me.
It's always a pleasure to have you on the show. Appreciate you coming and, again, as always, breaking down what are complex constitutional questions that apply to things that everybody in our society and culture are talking about. And so really, really appreciate your insight. Let's just start talking about TikTok and I'm going to start by running through a quick timeline. In 2002, Congress banned TikTok for federal employee devices. And then in 2004, Congress passed the Protecting Americans from Foreign Adversary Controlled Applications Act, which forced the parent company ByteDance to divest TikTok from China and sell to an American company in a certain amount of time, or the app would be banned from operating within the United States. This was a bipartisan vote, as I mentioned earlier, 79-18 in the U.S. Senate, 352-65 in the U.S. House, signed into law by then President Joe Biden. The ban was originally initiated by President Donald Trump, who now opposes it, and the reason for the ban. So there's a lot of confusion about why why Congress has gone after TikTok. The TikTok's user agreement has allowed their parent company ByteDance to access all user apps and files across all linked devices, including those that users didn't use to access TikTok. In Hong Kong, this data was used to track the whereabouts, activities, and communications of those who are protesting against the Chinese Communist Party and their crackdown in Hong Kong. Around the world, we know that China has utilized this data to hack and track journalists to try to get at their sources. And in the United States and elsewhere, we know that the data collection has been part of an estimated intelligence effort by the Chinese Communist Party, building a profile on how the countries and their citizens operate, including behaviors, patterns, susceptibilities, and the like. Congress argued this as a national security issue, but it's also been brought up now as a question of free speech. And that's where we begin tonight, looking specifically at the legal question that came before the Supreme Court in TikTok v. Garland this January. So, Alan, let me start there. What were the arguments that were brought before the Supreme Court, both from the U.S. government's perspective and from TikTok's perspective?
Right. Well, as you said, TikTok, who is opposing, obviously, this law, made it about free speech and said that they were being singled out as a platform, that it was hampering or stopping its users, as well as the company itself, from expressing their First Amendment free speech rights, and that in doing so, it was not what was called content neutral, meaning that they were being picked on essentially for what was being said on the app and like issues. The government made it sort of twofold related to what you said. It all came down to China and the fact that ByteDance is in China. And the idea was that the Chinese government is antagonistic to our government, Congress found. And the government defended this as first to keep the Chinese government from being able to get its hands on this information about Americans, because China has a policy where any company that is in its domain has to give over that information if the government asks. And the second argument that the government was willing to put out was the idea that this is being used, TikTok is being used to badly influence the debates going on in the United States about policy, international policy, domestic policy, so that it was trying to stop that kind of what it called disinformation. Those were the two main arguments for it.
And where did the Supreme Court focus their look into this case? We've talked in the past with other cases where it may sound like, for example, 303 Criada v. Elenis, where there may be an argument of a religious rights case or a same-sex marriage case, but the court narrowed it in and said, no, that's a free speech case. How did the court frame this case?
It really took up the question about the fact that these companies, the ultimate company, ByteDance, was in China, and the ownership and what the ownership of the company and where the ownership was taking place, China versus the United States, what that might mean for national security risks, for other security points. It really was not willing to take up the case of disinformation and its effect there. So did the government trying to address the background of an antagonistic government in China, its part in ByteDance, did that still violate free speech rights, or did the government have a legitimate interest and a legitimate purpose constitutionally for doing so?
I want to hone in on that a little, Adam. And you said the court really didn't look at this disinformation, misinformation question. And this is one of the points I think we see a lot on social media right now and on talk shows and things like that, where you hear people say, well, look, there's disinformation on Facebook and Meta. There's disinformation on Twitter, or X, formerly called Twitter. Why is TikTok being singled out? But what you're saying is that the court really didn't go down that route. When they were considering this case and the legality question here, they didn't really look at whether TikTok was being used as a propaganda machine.
Right. They noted that it had been made, but they did not focus their analysis there. And there were two concurring opinions. And if you look at Justice Neil Gorsuch's concurring opinion, he said that one reason he supported the main opinion was that it set that aside. It did not get into that issue because he said basically it's something that he doesn't think the court should get involved in. What is disinformation? What is misinformation? That is really for, he didn't use this phrase, but the equivalent of the free market of ideas. Individual persons consuming that information should be deciding for themselves. So that concurring opinion just affirmed that the court was not even taking up that issue, even though it had been brought to their attention.
Is that surprising to you? I mean, both of us teach constitutional law for a living. It seems to me that it would be messy for the court to kind of get into that question.
I think so. And the court, we'll talk about this, I think, a little bit more later, didn't have much time to make this decision.
That's right.
I think they were looking for unanimity, and they were looking, they said at the very beginning, they quoted an 80-year-old case where Justice Frankfurter, a famous 20th century justice, said, "We don't want the court and its decisions now to embarrass the future." And so I think they were looking for what was the narrowest grounds by which we could decide this particular case, knowing that A, they didn't have a lot of time, and B, that there was a lot of other implications here. So avoiding that messy issue, I think, was in line with what they thought was in the best interest of the court and to coming to a quick decision on the actual issue itself.
Yeah, you saw that in the opinion where they talked about really narrowing their scope on this case. Let me ask you this as well. This doesn't come up as much in conversations, but this was a bill that was passed by Congress. We went over those numbers. This was not a close bill. In fact, when I was there in the Senate in 2022, when they passed the bill banning it from federal government devices, and that went down 99-0 in the Senate. And there was a bill brought by Josh Hawley, who is very partisan in the United States Senate, and yet it was 99-0. So it's not controversial there. But how much would this have been different if Congress had not passed it and say this was an executive order? Was there any bearing that Congress had passed this? And I know it's not this is not really kind of the focus of the court, but would it have been different if it wasn't passed through Congress? Is there any sense here that the court is giving some deference to Congress's legislative authority?
I think they are. If it was an executive order, I think it would come down to what all executive orders should be judged by. Is it carrying out the law within the discretion the law gives the President of the United States? But when Congress passes it in their legislative capacity, then then the court, I think, is certainly even more willing than with presidents to give deference. And I think the fact that it was so overwhelmingly passed adds to that, because it really shows that Congress believed that this was a proper interpretation. So the court doesn't allow other branches to replace its own judgment, but it certainly gives those other branches respect, and it's part of the persuasive process. And you're right. This was one of the most closest to unanimous bills on a significant topic we've seen in a while in a very partisan Congress, a very divided era of government. And one thing that didn't get talked about a lot, but the Congress was privy to secret information that really couldn't be divulged. But even though we didn't get to see that, the unanimity from left to right, progressive to right wing to Democrat and Republican, I think shows you that they were very concerned with what they saw, enough to come to this almost unanimous conclusion.
Yeah. That's a great point. Adam, we're going to go to the break. When we come back, I want to talk about the decision that the court made and what that means for free speech, a few other social media platforms, and the like. So don't go away. We'll be right back.
Watch Lighthouse TV wherever you go. Available on Roku, Amazon Fire TV, and Apple TV. You can view our in-house studio productions on demand, or watch what's on the station right now with our 24/7 live stream. Search Lighthouse TV online on your streaming device, or go to our website for more information. Visit lighthousetv.org to stay connected. There you can find out what's currently on the air and coming up, how to watch in your area on cable, satellite, broadcast, or streaming devices. Watch past programs or our live stream. Follow us on social media and learn more about the station, our hosts, and our programming. Lighthouse TV, positively different.
Welcome back to Face the Issues. Adam, thanks again for joining us. And let's get into the Supreme Court decision here. The decision, to your point, was unanimous, and it was a per curiam decision. Before we go any further, could you just explain what per curiam means and why the court does it?
Yeah, it's a decision of the court, but in a different way than it normally proceeds. Normally, an opinion of the court is attributed to having been written by one particular justice, and then a majority of the court joins it. This per curiam opinion doesn't have an attributed author. The court as a whole is considered its author. And they usually do this in one of a couple situations, sometimes for shorter, less substantive, less controversial opinions. They'll shoot this off because it's a case that can be disposed of easily. But in a situation like this, I think it goes back to they had very little time to make this decision, very little time to move the different parts of writing. So I think they decided rather than attribute it to one justice, it was better to just have it be from the court in general, given those limitations and such.
And what was the ruling from the court? I mean, we know the decision was 9-0. We know it went against TikTok, but what was the ruling?
Well, the ruling was that the rules from the law requiring divestment of Chinese ownership or ownership in Chinese companies with TikTok could go forward, that it didn't violate First Amendment rights, at least as the court understood them, and that therefore they were not going to hold the ban, they were not going to overturn it. It could go into effect. I know that's an entirely separate question about now former President Biden and President Trump actually implementing it, but the court unanimously cleared the way for that ban to go in, or that limitation and those rules to go into effect.
Yeah. And how did they come to that decision? Obviously, we talked last segment about the free speech questions. What was the court's reasoning in getting there?
Well, back to TikTok's claim that it violated the First Amendment free speech rights, the court answered it several ways. One, it said this isn't directly about the content of the speech. It really didn't matter what was being said based on the way they determined it on TikTok. This law applied regardless. And so it wasn't targeting what someone said. It wasn't even targeting in a direct way who said it or how they said it, because it was entirely about the ownership of the company that was facilitating or making this speech. They also said that, yes, it's likely the case that this would, if implemented, affect people's free speech indirectly. But again, they said the main point was the interest the government had in data collection of American citizens, of American governmental contractors, of American governmental employees, and that because of those important interests that combined with what I said before, this wasn't really touching upon the core free speech issue, and it was reasonable as a way of addressing a pressing concern.
I want to ask you about strict scrutiny. Strict scrutiny usually is the standard that's employed when it comes to violating something like free speech, which is called a preferred right, because it is, again, it's preferred. It's something we don't want to violate if we can help it. But the court didn't use strict scrutiny in this case. What is strict scrutiny? How do we define that? And then why did the court veer away from it in this case?
Yeah, that's important. The strict scrutiny, the courts have developed over the decades different standards by which they judge laws, and these standards can go anywhere from rational scrutiny, which things like traffic laws get, where the government only has to prove that it had some rational reason and rational way of going about accomplishing that reason for the law to be considered constitutional. You then have heightened forms of scrutiny. So you have what's called intermediate scrutiny. That's where the government has not just any objective, but an important one, and not just any way of getting there, but a substantially related way of getting there. And then we have strict scrutiny, which is the highest, the hardest for government to justify its laws under. And that's where you have to have a compelling interest. So not just any, not just important, but some of the most important reasons you would even have a government. And then the narrowest way, narrowly tailored or least restrictive way of going about that. So cases like laws that have to do with race would be usually the example used there, in addition to free speech cases. So that all sets up why in this case didn't they apply strict scrutiny. It was again going back to the essence of the free speech protection for the court was to let people speak freely and not be judged based on the content of what they said or who they are and what they said. And the court went back again and again to the idea that no one's being censored for what they said. They're not being censored for who they are in relation to their speech. This has entirely to do with other issues of national security related more to access to information, not actual words or messages or other things like that. So they actually applied intermediate scrutiny and said that given the potential bad things that could come out of Chinese government access to these things, it more than met that standard, which of course is lower than strict scrutiny.
Do you think dispatching the claims about misinformation and saying we're not going to rule on that, like we're not going to bring that into consideration in this ruling, does that help them be able to step away from strict scrutiny then?
I think it did, and I think they didn't come down hard on that question of which scrutiny they were going to do, partly because Justice Sotomayor also wrote a concurring opinion, and it seems that she and Justice Gorsuch weren't entirely sure whether strict scrutiny should apply, but a majority of the court did think it shouldn't apply. And what's interesting, by the way, is Justice Gorsuch said, I think strict scrutiny applies and I think the government still wins. Yeah. Like this is a rare exception where something is so compelling that it overwhelms those interests. So again, that might be another reason for a per curiam opinion that I didn't mention is not allowing the court to maybe not hide, but mitigate the underlying points of disagreement and just focus on what they could all agree on to come to the conclusion they did.
One of the things that came up in the case, it wasn't a main focus, but it's come up a lot in conversation, is whether or not TikTok has any free speech rights, which brings up the question, one, do platforms have free speech rights? Does Meta have free speech rights? And then secondly, TikTok not being an American company, being owned by a Chinese corporation, do those foreign entities have free speech rights? What did the court say about those questions?
Yeah, I'll take that in reverse order if you don't mind.
Sure.
The second, there is a footnote that explicitly says that foreign companies, as they operate in foreign countries, don't have First Amendment rights. And that's because the First Amendment is the U.S. Constitution and it applies to the United States and to the people of the United States. And so to extend it to another country and another country's companies just doesn't comport with the idea of nationhood and the idea of constitutions in relation to law and the geographical distinctions of law. So that didn't completely solve things because TikTok also has an American element. So there is some things that I don't think got completely cleared up about how you distinguish the two when they're when a company has a partly American section of it and a partly foreign. But your other question about does TikTok have First Amendment or free speech rights? This is another thing that I think the court is only now starting to work out. In recent precedent, the court has said to some degree, I think yes, found that that's the case. But I don't think they've worked out exactly what that means and exactly how that operates. And I think that's another reason why they felt that they needed to emphasize that this isn't regulating the content of the speech and therefore is not, in their opinion, affecting even the more expansive views of First Amendment rights of those platforms. But yeah, we're still working out what that all looks like, and the court's been kind of late to the game, and I think hasn't quite come to a definitive conclusion on those questions.
Last question: do you think this is going to impact any attempt from Congress to regulate other platforms? And we hear that all the time. They should regulate Meta. They should regulate X. Do you think this decision has any impact on that, or is this kind of a different kind of opinion because of who TikTok was?
I think the latter, because they were so careful to say this really has to do only with a situation that's hard to see many parallels to TikTok's. It has to do with not just a parent company being in another country, but that country being found to be antagonistic to us, a well-founded history of collecting data information on the platform, and again the content neutral claims that they made. I think that if you had a law that was touching on one of these more decidedly American-based companies, or which was really trying to determine the content on the platform. Because again, this had nothing to do with what content was on the platform from the court's perspective, just who owned the access to the information coming out of the platform. If you were to do one that really was about what was actually going on, what was actually being produced on, say, Facebook or X or something, this really just doesn't apply, and there's implications that the court would not be willing to go in that direction and would not see this as a precedent for something that was more based on the content of the platform.
Yeah. Adam, thank you so much. Really appreciate your insights into this case and this topic. Don't go away. We'll be right back.
Watch Lighthouse TV wherever you go. Available on Roku, Amazon Fire TV, and Apple TV. You can view our in-house studio productions on demand, or watch what's on the station right now with our 24/7 live stream. Search Lighthouse TV online on your streaming device, or go to our website lighthousetv.org for more information. Lighthouse TV, positively different.
Welcome back to Face the Issues. Adam, thanks again for joining us and for your insights. As we close out, our viewers may have noticed that you have a different title in lower third than the past. You've been at Hillsdale College, and now you're back at your alma mater, Ashland University in Ashland, Ohio. And part of your role there is you're co-director of the Ashbrook Center. Could you tell us a little bit about the Ashbrook Center, the vision, the purpose, and what your role there is?
Yes, and I should say I'm also an alum of the Ashbrook Center. It's done much to help me in my life and where I am now. And the center is focused on education. It's focused on especially civic education and informing students and citizens on the principles of the United States, the history of the United States, to help them be better governors, to teach them self-government and help them be part of this great experiment in a government of, by, and for the people. And so there's a student program involved on the university. There's teacher programs for 7 through 12 social studies and histories teachers. And there's a podcast. There's just all sorts of information to really help people think about what this great American experiment is and how we can better take the heritage that we were handed by our forefathers and self-govern in the future ourselves.
That's fantastic. As Ben Franklin said, it's a republic if we can keep it, and you guys are doing that work every day. So I really appreciate that. And Adam, thank you again so much for joining us.
My pleasure. Thanks for all you do here to have a way to have this kind of civil, thoughtful, educational conversation.
Oh, thanks, Adam. We appreciate you and look forward to the next time you're on.
Great.
That is our show for this evening. I want to thank my friend Dr. Adam Carrington of Ashland University and the Ashbrook Center. And of course, I want to thank each of you for tuning in. We hope to see you again right back here next week. Until then, my name is Sam Chell. On behalf of all of us here at Face the Issues, thank you and good night.